The following presentation expands on a topic introduced in the 2-hour video, How and Why FINRA Manipulated the MMTLP Corporate Actions Part 3. This video can be found on YouTube. In this video, we'll first provide some insight into SEC Rule 15C211. In a nutshell, SEC Rule 15C211 requires broker-dealers to make current and publicly available information about the issuer and its security accessible to investors before they can provide price quotations in the over-the-counter OTC market. In February of 2020, Ari Rubenstein sent a comment letter concerning proposed amendments to the rule that were intended to offer better protection for investors. In this video, we'll examine this 7-page comment letter, but we'll attempt to do so from the perspective of the SEC that should have carefully reviewed the letter, considering the source, the arguments presented, and the potential impact on the market as a whole. This is important because, as we'll address in the video, Ari Rubenstein and his GTS Securities were subjects of an SEC probe relating to a direct listing, shortly before submitting this comment letter. Rubenstein's comment letter offers the unique perspective of his thoughts and ideas from the time the letter was composed. Time has provided the ability to peer into the financial condition of GTS Securities at that time, and even if we don't have the ability to see the exact details of their proprietary trading activity. In my opinion, the comment letter and the additional content in the video shows that Rubenstein intentionally intended to engage in activities that he knew weren't in the best interests of multiple issuers and investor groups, but that were ultimately intended to benefit himself, his firm, and those with whom he potentially coordinated. It isn't difficult to imagine that Rubenstein's motive for this behavior was likely influenced by the recent attention on short squeezes in GameStop, and the fallout that came at the expense of the firms on the wrong side of those trades. The video includes eyewitness testimony and evidence placing Rubenstein's GTS Securities and alleged co-conspirators at the scene of multiple crimes, in addition to a history of disclosures and allegations that indicate a history of nefarious acts on multiple exchanges over a span of multiple years at a time. By taking a page out of Bernie Madoff's playbook, Ari Rubenstein appears to endear himself to regulators by leveraging technology and offering his services, or by recruiting talent and then relying on those established relationships to manifest into benefits for Rubenstein and his ventures. Rubenstein only had to be successful at this strategy long enough for his firm to become essential, or at least be seen as essential to the stability of the market. By the time GTS Securities prompted the New York Stock Exchange to begin an investigation, they were already their largest designated market maker with an obligation to provide liquidity for some of the biggest names in the market. When your role in the market is essential, you're seemingly governed by a different set of rules. When you're aware of your status, you can get away with things like impeding investigations and negotiating acceptance, waivers, and consents with small fines that might never be collected. So if a nefarious market maker, for example, knew that they could get away with any crime with just a slap on the wrist or a get-out-of-jail-free card, wouldn't they be more likely to engage in risky behavior? When the actions of Ari Rubenstein, his employees, those linked to him, and his businesses are observed in full context to his manifesto-like comment letter, his disclosure history, and his sudden disappearance shortly before FINRA U3 halted trading in MMTLP, you're able to piece together a compelling narrative that should at the very least warrant an investigation into his firm's trading activity and short-selling obligations. And to anyone watching this in disbelief that the regulators would protect a market maker, just watch the rest of the video and see if you feel the same way afterwards. Disclaimer: there are a number of poorly worded sentences and mispronounced words throughout this presentation that, when fixed, resulted in bigger issues. For this reason, they were left as is. Hopefully they don't take away from the overall message. Rule 15C211 under the Securities Exchange Act of 1934 governs the publication of quotations for over-the-counter, or OTC, securities. It aims to ensure that there is adequate and current information available about the issuer of a security before it can be quoted on the OTC market. Here's what Rule 15C211 says about a market maker's responsibility to use up-to-date information when relying on an exemption to get a security trading on the OTC without a Form 211. General requirement for information review. Rule 15c211 generally requires market makers to review certain information about an issuer before publishing a quotation for its security. This information is typically provided through a Form 211 filing with FINRA. The rule mandates that there must be current public information about a company to facilitate a broker-dealer's information review, ensuring accuracy and reliability. Exemptions and the piggyback exception. There are certain exemptions to the Form 211 filing requirement. One important exception is the piggyback exception. This exception allows a broker-dealer to rely on an information review completed by another broker-dealer or an information repository like OTC markets. However, even when relying on an exemption like the piggyback exception, the market maker still has a responsibility to have a reasonable basis for believing that the information they are relying on is accurate and current. The market maker's duty to have a reasonable basis for believing the information is accurate and current is an ongoing one. This means that even if they initially relied on another source, they must continue to monitor for any material changes in the issuer's information. If a market maker becomes aware of any red flags or information that suggests the information they are relying on is no longer accurate or complete, they have a duty to investigate further. If a market maker publishes quotations based on outdated or inaccurate information, they could be subject to disciplinary action by the SEC or FINRA. In essence, even when using an exemption to avoid filing a Form 211, a market maker cannot simply rely on old information. They must take reasonable steps to ensure that the information they are using to publish quotations is current and accurate. This is crucial for maintaining transparency and preventing fraud in the OTC market. It's important to consult the full text of Rule 15c2-11 and seek legal advice for specific situations, as the rule is complex and has been subject to amendments. Here's where things get interesting. In a comment letter to the SEC dated February 26, 2020, GTS Securities CEO Ari Rubenstein proposed amendments to 17 CFR 240.15c2-11. The subject matter: publication or submission of quotations without specified information. Being that it has now been nearly 5 years since this comment letter, the commentary is highly influenced by the controversies that Ari Rubenstein and GTS have been connected to before, during, and after the IT was submitted to the SEC. Once we're done with going over the comment letter, we'll look at some of these real-life examples that appear to prove Ari Rubenstein wasn't being entirely genuine. On the first of 7 pages, Rubenstein includes the following excerpt from the SEC's proposed amendments. Are intended to modernize the rule and in so doing better protect retail investors from incidents of fraud and manipulation in OTC securities, particularly securities of issuers for which there is no or limited publicly available information, and facilitate more efficient trading in certain more widely followed OTC securities. The SEC's aim was to require broker-dealers to review and retain specific information about issuers in order to provide investors with more accurate and up-to-date information. The rule was intended to deter fraudulent and manipulative practices by making it more difficult for bad actors to disseminate false or misleading information about securities. By ensuring that broker-dealers have adequate information, the SEC sought to promote fair and orderly markets where investors can make informed decisions. The SEC's original intent was to strike a balance between investor protection and market efficiency. The rule was designed to impose reasonable requirements on broker-dealers while avoiding unnecessary burdens on the industry. With this in mind, pay close attention to the content of Ari Rubenstein's comment letter. On page 2, Rubenstein provides an overview of the OTC and how important it is to capital formation. He also included information like, the investors that buy and sell OTC equity securities are as diverse as the securities that trade on the OTC market. In our experience, investors in OTC securities are not just retail investors, but run the gamut from self-directed individual investors to hedge funds, pension funds, and registered investment advisors. Thus, the experience level and sophistication of investors in the OTC marketplace many times exceeds that of other more traditional marketplaces. This is further evidenced by the range of comment letters submitted on this proposal. He then proceeded to provide 8 examples of what he referred to as high-quality companies on the OTC whose financials may or may not be easily obtained. Most of the examples Rubenstein used are of companies that have existed since the late 1800s and early 1900s, when the rules and record-keeping standards probably weren't as strict as they became more than 100 years later. In using these examples along with the other content of this comment letter, Rubenstein appears to attempt to justify giving broker-dealers leniency at the expense of protecting investors and issuers. This becomes clearer and clearer as you continue to read. At the bottom of page 2, Rubenstein provides the following example. The tile shop, TTSH, recently disclosed that it has filed a Form 15 with the SEC to deregister its stock. Consequently, the company is no longer required to publicly disclose corporate information after the deregistration becomes effective. Should investors be deprived of an active marketplace because of this? According to the October 22, 2019 PR from the tile shop, the fact that their shares were only owned by fewer than 300 holders of record factored into their decision and the ability to deregister. The company's CEO put it this way: "We've undertaken a thorough and thoughtful review of our cost structure, including costs associated with being a NASDAQ-listed and SEC reporting company. After careful consideration, our board of directors decided to voluntarily delist from NASDAQ and deregister with the SEC, as we believe the savings that will benefit our shareholders outweigh the advantages of continuing as a NASDAQ-listed and SEC reporting company." The company also included that they anticipated that the last day of trading on NASDAQ will be on or about November 8, 2019, but that the company's common stock may thereafter be eligible for trading on an over-the-counter market. This is an interesting example because this security was being voluntarily delisted and deregistered from the NASDAQ, and the issuers clearly understood that the company's stock may become eligible to trade on the OTC if one or more brokers chose to make a market. Rubenstein asked if investors should be deprived of an active market because of this. This question doesn't even apply to this situation, because the company provided approximately 2 weeks' notice before the final anticipated trading day on the NASDAQ, and they made it clear that there was a reasonable expectation that trading of the security could continue at some point on the OTC. Rubenstein tries too hard by including this example, and he likely didn't count on anyone looking into the particulars. But what if we were to slightly alter the circumstances? What if TTSH was taking part in a reverse merger, after which every holder of TTSH would be the recipient of a dividend that the issuer told investors they could only receive by holding TTSH through the merger? And what if the issuer said that there was no reasonable expectation that the shares would ever become tradable? In a scenario like this, investors are given the impression that the only way they can ever receive this dividend is to hold their TTSH shares through the merger. If enough investors were interested in receiving the dividend, the price of TTSH might increase, and investors that really wanted the dividend would have to resist the urge to sell, because the messaging from the issuer stipulated that holding through the reverse merger would be the only way to receive the dividend. So let's say there were long-time TTSH holders with averages in the 25 cents range, and let's also say that there were new buyers of TTSH on the final day that paid more than $10 per share. Regardless of whether you thought it was wise for the investors with 25-cent averages to not sell, or if you thought it was unwise for the investors that bought shares over $10, both groups of investors made their decisions based on being under the impression that holding through the reverse merger was the only way they could receive the dividend. Stay with me here. We also have to assume that the company would provide the same information in their filings and PRs as they did in the real-life example. So if a broker-dealer or two sought to create a market for the dividend after the reverse merger, wouldn't it be the responsibility of the broker-dealers to be up to date on the information that's publicly available? Rubenstein asked if investors should be deprived of an active market, even though the issuer said in their PR that a market would likely develop on the OTC. The question that should be asked now is, should the investors that held their shares through the reverse merger in order to receive the dividend be taken advantage of by allowing a market to form for the dividend that goes against the wishes of the issuer and the expectations of the investors that held their TTSH shares in order to receive the dividend in the only way they were led to believe was possible? Anyone that believes in a fair and orderly market would have to agree that allowing a market to form for the dividend wouldn't be fair to the investors that held their TTSH shares through the merger in order to receive a dividend. But let's say that broker-dealers relied on an exemption that allowed a market to form regardless of the issuer's wishes. The fact that the issuer included in their filings and in the PRs that it wasn't their desire nor their anticipation that a market would form, the broker-dealers that still proceeded to make the dividend tradable would be doing so while having full knowledge that they were acting in opposition to the issuer and the majority of the investors that would be caught off guard. Rule 15c211 was designed to protect investors by requiring broker-dealers to have a reasonable basis to believe that information about an issuer of OTC securities is accurate and reliable before publishing quotations for those securities. The rule was intended to prevent the dissemination of misleading or inaccurate information about OTC securities, which could harm investors. Because the issuer clearly stated in their filings and PRs that they didn't desire a market for the security, nor did they anticipate one forming, broker-dealers should have understood that by creating a market in such a situation could be seen as going against the issuer's wishes and potentially causing harm to investors. But let's give the broker-dealers the benefit of the doubt that maybe they just didn't see the information regarding the issuer's wishes and the circumstances by which the investors believed were the only way they could receive the dividend. Let's say a market formed. The shares that some investors paid up to $10 per share for TTSH in order to receive 1-for-1 shares of the dividend were now trading for 10 cents, then gradually up to $3 before dropping back down to under $2. Investors that held the dividend had no clue what was happening. Most brokerages allowed them to sell, but very few brokerages allowed them to buy more. Once the issuer informed FINRA what occurred and why it shouldn't have happened, wouldn't you expect FINRA to halt trading and rectify the situation before it could get further out of hand? You would if you believed in a fair and orderly market. FINRA could have easily unwinded the trades and revoked the trading symbol if they were made aware that the broker-dealers created a market for a security contrary to the issuer's intentions and that caused harm to investors. By the way, this hypothetical scenario is almost exactly what happened in the case of MMTLP. At the top of page 3, Ari Rubenstein includes one final example that goes as follows. Hanger Inc., HNGR, Tango Inc., TNGO, since acquired, Supermicrocomputer, SMCI, MyMedics Group Inc., MDXG, are examples of companies whose financials became deficient due to a need to restate. Some of these remain trading OTC, while others have gotten their financials back in order and relisted back on exchanges. Again, depriving investors of a continuous market due to a lack of financials seems a mistake, and would effectively deprive investors of an active marketplace in which they can decide to stick with a company going through turmoil or close an investment. Having a continuous active marketplace enables investors the ability to make their investment decision and execute upon it in an efficient and effective manner. Rubenstein makes it clear that his idea of protecting investors is to make sure that they always have the ability to trade on an exchange, and if this isn't possible, there should be a way for the security to trade on the OTC. While this sounds virtuous, the exemptions to Rule 15c211 also make it easier to create a market for securities that perhaps shouldn't be trading. One of the main points of Rubenstein's 7-page comment letter can be found on page 3, where he first mentions that, although information about a company may be hard to come by, investors should not be deprived of opportunities to trade the stock with market makers. Such opportunities are likely to disappear if the Commission adopts the proposed amendments to the Piggyback provisions of Rule 15c211. A large aspect of a market maker's business model is the profits they make from bid-ask spreads. So while Rubenstein can say that he cares about investors, there's no denying that there's a financial incentive for creating markets. Rule 15c211 is about improving the quality of information available to investors, reducing the risk of fraud and manipulation, and promoting fair and orderly markets. We're talking about a rule that prioritizes having up-to-date and accurate information. But somehow, Rubenstein shows his concern for the unintended consequences of requiring up-to-date and accurate information when he wrote the following. As with any rule change, the cost versus benefit analysis is a critical part of the rule assessment. Any rule change must balance the potential to deter fraud with any unintended harm that may be caused to the marketplace, investors, or underlying issuers. What unintended harm to the marketplace, investors, or underlying issuers could come as a result of implementing stricter requirements for accurate and up-to-date information? The more the comment letter goes on, the more Rubenstein made it apparent that he was only looking out for his own interest as a market maker. Rubenstein continues, "The uniqueness and complexity of the OTC market make it difficult to draw a causal relationship between delinquent or unavailable company financial information and fraud. Fraud and manipulation are typically the result of bad actors intent on creating schemes to enrich themselves at the expense of unsuspecting investors. Identifying these fraudsters and freezing their money flows is far more impactful and will directly reduce fraud in the marketplace, whether in the OTC market or national exchanges." Rubenstein downplays the significance of delinquent or unavailable financial information, claiming that the real bad actors are those that create schemes to enrich themselves at the expense of investors. What he doesn't do is he doesn't entertain the idea of a scheme involving bad actors using delinquent and/or falsified information to facilitate creating a market that shouldn't exist. This shifts the focus away from the systemic issues within the OTC market that the rule was intended to address and basically tells them to look elsewhere. But how are bad actors intent on creating schemes to enrich themselves at the expense of unsuspecting investors? Any different than market makers like Ari Rubenstein's GTS Securities? GTS has a long list of disclosures in FINRA's database detailing schemes from every exchange that they've done business on, establishing a pattern of infractions or schemes that provided enrichment for GTS at the expense of unsuspecting investors. What's especially ironic here is that at the time of this comment letter, Ari Rubenstein was a member of FINRA's Market Surveillance Advisory Group. As a member, GTS Securities lent their technology to FINRA to help them locate market manipulation, such as spoofing by other high-frequency trading firms. Simultaneously, GTS Securities was found to be engaged in a variety of market manipulation, including spoofing on the New York Stock Exchange. So how is it that GTS had the technology to help FINRA identify market manipulation, but they neglected to identify the manipulation taking place at their own firm? The irony continued with the following passage. "The Commission already has powerful tools it can use if it believes that an issuer's securities are the subject of fraud or manipulation. For example, Exchange Act Section 12, K1, authorizes the Commission to suspend trading in any security if, in its opinion, the public interest and the protection of investors so require. The Commission already uses this authority extensively." This reads as if he was saying that even if Rule 15c211 failed, the Commission has the ability to suspend or halt the trading of a security that they believe is the subject of fraud or manipulation. What I believe this shows is that if Rubenstein was aware of the SEC rule about imposing a trading halt, there's also a strong likelihood that he was aware of FINRA's ability to U3 halt a security. The last paragraph on page 3 leading into page 4 touches on the topic of catch-all issuers, which are companies that don't neatly fit into other categories defined by the rule and may have limited information available. The proposed amendments to Rule 15c211, specifically those that address the catch-all issuers, are not likely to eliminate fraud or manipulation. Eliminating the actively quoted and public marketplace where investors can get published electronic quotes for catch-all issuers will instead make it more difficult to value assets. Publishing a quote is not an enticement to trade. It is in fact information which investors can use to make better buying and selling decisions, determine best execution of their trades, as well as help value their holdings. Precluding or terminating quotations for catch-all issuers will lead to unintended consequences, including the reduction of transparency, distortion of price discovery, and general obfuscation of the marketplace, impacting brokers' ability to provide and measure best execution. Here Rubenstein very plainly claims that the proposed amendments to Rule 15c211, specifically those in relation to catch-all issuers, are not likely to eliminate fraud or manipulation, but instead, eliminating a public marketplace where these catch-all issuer securities can be quoted will make it more difficult to value assets. There's a clear bias here. There could be any number of reasons why the value of a security could be in fact greater, due to the fact it isn't being publicly traded. Before initial public offerings, for example, a security is thought to be valued at a certain price, and then when it trades publicly, the market either shows that it agrees that the price was too low or that the price was too high. But even this metric can be impacted by outside factors such as market trends, the economy, the price of oil, a pandemic, a war, or even manipulation that wouldn't otherwise have been possible if the security never traded. So why would an investor want the fate of the value of their non-trading security dictated by a market maker that profits from creating a market for that security regardless of the value? Wouldn't it make more sense if the process involved the issuer, especially if the issuer stood to benefit in the same way as their shareholders? And here's a random thought, likely of no significance. Did you know that a Series A preferred share, representing interest in an oil asset of a company that is no longer in existence, very likely falls within the catch-all category under Rule 15C211? Being that the issuing company is no longer existence, it would likely make it difficult to obtain current financial information and assess the value of the underlying oil asset, nor accurate information relating to key roles in the company. Information about the oil asset itself, reserves, production, etc., may be scarce or outdated, further complicating valuation. But if the issuer made it clear that there were no intentions for this Series A preferred share to trade, then lacking this information along with recognizing the wishes of the issuer should prevent a market participant from attempting to create a market. This next quote is a real head-scratcher. Publishing a quote is not an enticement to trade. It is in fact information which investors can use to make better buying and selling decisions, determine best execution of their trades, as well as help value their holdings. Rubenstein makes the definitive statement that publishing a quote isn't an enticement to trade, but at the same time he refers to it as information which investors can use to make better buying and selling decisions, otherwise known as trading. Publishing a quote is in fact an enticement to trade. It's the same as receiving an offer to sell your car that you weren't thinking about selling until you received the offer. Interestingly, Rubenstein quotes a career criminal in the next paragraph when he stated the following. As career criminal Willie Sutton once said, "I rob banks because that's where the money is." Capital markets will continue to be targeted, and criminals will become more sophisticated in evolving their methods. Because of this, we fully agree and support the Commission's efforts to root out fraud and vigorously pursue those individuals who perpetrate illicit acts. However, adding unnecessary friction can permanently damage the OTC marketplace, bona fide issuers, and the ability of investors to participate in the OTC space. This is what I hear when I read this. Hey SEC, the crimers are going to crime and their crimes are going to become more sophisticated. Because of this, we fully agree and support the Commission's efforts to root out and prevent some of these crimes. But anything that will stand in the way of market makers making money, or even the types of crimes that we like to engage in and that you allow us to get away with, well, that's what I consider unnecessary friction that can permanently damage the OTC marketplace, bona fide issuers, and the ability of investors to participate in the OTC space. The next section of the comment letter, still on page 4, is given the header of information for some reason. Here, Rubenstein continued to argue that the proposed changes to Rule 15C211 are overly restrictive and could harm the functioning of the OTC market without sufficient justification. Here specifically, he addresses the 1984 amendments to the rule that recognized that quoted prices reflect market supply and demand, indicating sufficient information is available to investors. In other words, this was in support of the piggyback exception. The proposed changes to the rule would require current information about the issuer to be publicly available within 6 months for the piggyback exception to apply. According to Rubenstein, 6 whole months to locate information could significantly hinder market liquidity, effectively suspending trading in many securities, even without evidence of harm to investors. He constantly went on about the exemption being crucial for an efficient OTC marketplace, promoting competition and price discovery, and how the proposed modifications were seen as excessive and could negatively impact investors and issuers. But again, this section was specifically about having 6 full months to locate information in order to continue relying on a piggyback exemption. This doesn't sound as unreasonable and potentially detrimental as Rubenstein made it seem. It's almost as if these exemptions served a nefarious purpose, and that Rubenstein was fighting for dear life to ensure they remained. I skip ahead over the section of page 5 where Rubenstein describes the minimum amount of information that investors need, and I instead bring your focus to section where he offered suggestions. This is the text, Piggyback Expansion. Importantly, there is room to reduce the burden of Rule 15c2(11) by expanding the criteria for the types of securities which would be eligible for exemption from the rule, allowing market makers to quote immediately without diminishing investor protections. For example, additional classes of shares if the primary shares are listed on a U.S. securities exchange. Derivative securities such as warrants, rights, units, contingent value rights, preferred, and convertibles if the primary shares are listed on a U.S. securities exchange. American depository receipts and ordinary shares of foreign companies whose primary shares are listed on a foreign securities exchange/new equity securities of companies that have emerged from bankruptcy, and when issued securities of the types listed above. Can you see what's going on here? The SEC was proposing adding a step in the form of adding a 6-month time limit to provide information when a market maker relied on the piggyback exemption that hadn't been updated in nearly 2 decades. Rubenstein not only argued against the change, but he also suggested that piggyback exemption be expanded so that it would be less burdensome for market makers to create markets for what seems like every type of security imaginable. Now take a moment to think about this. Even if as a market maker, you were the most honest, responsible, and by-the-book operation, wouldn't you see this suggestion as one that could easily lead to nefarious acts from the more questionable firms that you, as a member of FINRA's Market Surveillance Advisory Group, are clearly aware of? 5 pages into the 7-page comment letter, Rubenstein finally made his intentions clear. His concerns about the proposed amendments to Rule 15c2(11) weren't about investors, issuers, or the stability of the OTC market. Rubenstein, for some odd reason, was trying to ensure that he'd continually have access to exemptions as a market maker, while also campaigning for an expansion to those exemptions. The suggestions continue on the top of page 6. Here Rubenstein described a task force. A key component to combating fraud is the establishment of a task force, comprised of various industry participants assigned with addressing issues on a real-time basis. This construct would allow for a more rapid and effective response to potential issues. Such a task force would include members from brokerage and market-making firms, transfer agents, DTC, FINRA, the SEC, exchanges, and IDQS and ATS operators. Making a suggestion like this does give the impression that a person is sincere. But at the time of this comment letter, Rubenstein's GTS Securities lent their technology as a member of FINRA's Market Surveillance Advisory Group to aid FINRA in identifying manipulation on behalf of other high-frequency trading firms. As a result of a New York Stock Exchange investigation that began a year after this comment letter, it was determined 2 years after the investigation began that Rubenstein's GTS Securities was involved in a variety of manipulation on the New York Stock Exchange and NYSE Arca for approximately 6 years, including a type of spoofing which was among the same type of manipulation that GTS allegedly helped FINRA to identify on the OTC. It's important to note that GTS Securities, along with Canaccord Genuity, a firm often associated with GTS, were named in at least 2 spoofing lawsuits introduced by OTC issuers, during the same time frame that GTS was involved with manipulation on the New York Stock Exchange and NYSE Arca. It doesn't take a genius to at least recognize what appears to have been going on here. Rubenstein appears to have taken a page out of Bernie Madoff's playbook. By forming working relationships with the regulators, in this case, FINRA's Market Surveillance Advisory Group, Rubenstein and GTS Securities gained their trust and were seemingly put in charge of policing a certain segment of the market that allowed them to avoid detection. If true, this makes sense that Rubenstein would suggest that market makers be involved in a task force along with brokerages, transfer agents, DTC, FINRA, the SEC, exchanges, IDQS, and ATS operators. Along this same level of giving the appearance of caring, Rubenstein offered the suggestion of requiring transfer agents to keep accurate information regarding an issuer's outstanding shares. While this isn't a bad idea, transfer agents primarily track shares officially issued by the company. So if share counterfeiting or naked shorting were to take place, then this wouldn't be reflected in the transfer agent's records. Also, depending on how many securities a transfer agent handles, tracking every time each issuer issues shares sounds like a greater burden than the proposed 6 months for a market maker to locate current information a single time. The last suggestion on page 6 with the header, Broker Disclosure, is a little wordy, but it's important to address. Along the lines of the OTC market disclosure standards, brokers should be required to inform their clients about the level of public disclosure a company makes. This requirement should apply to all broker-dealers and should be mandated on a pre-order entry basis. This requirement will help to ensure that investors, retail and institutional, are explicitly informed about the quality of issuer information prior to making investment decisions, rather than prohibiting a broker-dealer from publishing quotations if an issuer is delinquent in its reporting obligations but is not the subject of adverse SEC action. This disclosure would put the investor on notice that they should take the quality of issuer information into account in making investment decisions. This is consistent with the foundational principles of the federal securities laws, that is, disclosure and transparency. Regulators should be very wary of injecting their views as to whether an investor should buy or sell a security. Rather, ensuring full and accurate information is available to investors to allow them to make informed investment decisions is the cornerstone of our capital markets. The first part of this makes sense. By requiring this disclosure up front, investors are given crucial information that allows them to make more informed investment decisions. Investors can assess the quality of information available about the company and its potential impact on their investment. This approach enhances transparency in the broker-client relationship, ensuring that investors are not misled about the level of information available about the companies they are investing in. But it's the way he ends this portion of text that's a contradiction. Rubenstein stated, "Regulators should be very wary of injecting their views as to whether an investor should buy or sell a security. Rather, ensuring full and accurate information is available to investors to allow them to make informed investment decisions is the cornerstone of our capital markets." He's saying that the regulators should be ensuring that there's full and accurate information available to investors. But this contradicts allowing brokers to provide pre-order prompts when they know that full and/or accurate information isn't available. In saying that regulators should be ensuring that full and accurate information is available to investors, Rubenstein also contradicts the proposed 6-month period that the SEC planned to give market makers in order to provide full and accurate information when the piggyback exemption is utilized. In both including so much content into these 7 pages and including contradictions such as these, I kinda get the impression that maybe Rubenstein assumed the comment letter recipient would be swayed to go back and incorporate his suggestions based on believing they were in alignment with his contradictions. And even if that's a reach, what isn't debatable is that the entirety of the comment letter to this point has only been about ensuring market makers continue to have the ability to rely on exemptions, possibly expanding those exemptions, and preventing additional responsibilities for market makers, but all under the guise of protecting investors, issuers, and price discovery on the OTC market. On page 7, Rubenstein, I believe, makes it abundantly clear what his true concern was because after spending 6 pages addressing Rule 15C211, he then changes the subject to regulations show, specifically the close-out requirements of Rule 204. Read it for yourself. As a registered market maker in thousands of stocks, we stand ready to provide continuous liquidity to broker-dealer clients and non-client contraparties. Our trading counterparties value and depend on our liquidity provisioning. In less liquid securities, however, our ability to meet liquidity demands when acting as a bona fide market maker are made significantly more difficult by the closeout requirements of Rule 204 of Regulation SECO. The financial exposure posed by the existing T+5 closeout period is an impediment to efficient price discovery and continuous liquidity. As supported by the academic paper, Squeezing the Shorts in Small Cap Stocks by Roberto Rico, Regulation HO, as currently constituted, may in fact be more of a catalyst for manipulation of securities than the piggyback exemption is. At the time of the comment letter, Regulation HO hadn't been updated in approximately a decade, so Rubenstein couldn't have brought it up as if to say the recent amendments to Regulation SAO were a bigger issue that needed to be addressed. To the reader, this paragraph should make you question the financial condition and business practices of Rubenstein's GTS securities. You see, Rule 204 of Regulation SAO requires that member firms close out, fails to deliver, or FTD positions within an established time frame. Fails to deliver occur when a seller of a security can't deliver the shares to the buyer on the settlement date. Rule 204 states that firms must either purchase the necessary securities to fulfill the obligation or borrow the securities in order to deliver them to the buyer. If a market maker relies heavily on short selling, which is selling borrowed securities, then there's a possibility that might frequently encounter fails to deliver. Rule 204 forces these market makers to have to quickly cover these positions, potentially at unfavorable prices, because if the price of the security has risen significantly, then this can create a significant burden on the market maker's business, potentially forcing them to sell other holdings in order to fulfill their obligations. And what you wouldn't have had the ability to see at the time that Rubenstein submitted this comment letter is how much the liabilities increased from 2019 to 2020, particularly in the securities sold but not yet purchased category. According to GTS financial statements, at the conclusion of 2019, their securities sold but not yet purchased were just over $615 million. At the conclusion of 2020, this amount increased to over $7,112 million, an overall increase of over $6.5 billion in liabilities when their previous high wasn't even $1 billion yet. Rubenstein wasn't bringing up the close-out requirements of Rule 204 because his concern was about investors, issuers, or the market as a whole. He was clearly in over his head making risky bets that left his firm with very little room for mistakes if they were ever forced to deliver the shares that they sold without first locating. Rubenstein then included a conclusion to his comment letter, reminding the Commission that their proposed amendments were too broad and that they'd undoubtedly result in negative unintended consequences that wouldn't deter manipulative activity. But he, of course, pointed to his suggestions as being the more suitable course and welcomed the opportunity to discuss them further. In 2019, shortly before this comment letter, Ari Rubenstein's GTS Securities was named in a probe concerning the direct listing of Slack Technologies on the New York Stock Exchange. The issue stemmed from Slack's direct listing, which allowed existing shareholders to immediately sell their shares, rather than being prevented from doing so by a lockup period. A lawsuit argued that the lack of a lockup period and the simultaneous trading of registered and unregistered shares made it difficult for investors to determine which shares they were buying and potentially misled them. A month before the probe, Rubenstein had this to say: "The recent collapse of newly public tech stocks, such as Uber Technologies, Lyft, and Slack Technologies, leads to an unavoidable conclusion. The process by which American businesses raise capital is broken. Many of today's most innovative and fastest-growing companies spend years incubating in the private market, to the benefit of a minority of investors, because of outdated regulations that dictate how companies can raise funds. Main Street investors are being left out in the cold." Rubenstein didn't deny that average investors received the short end of the stick. Here he clearly stated that the way American businesses raise capital is broken, and then proceeded to blame what happened on outdated regulation. Perhaps Rubenstein lacked media training at the time, because when Citadel provided comment after the probe began, this is what they said: "The direct listing of Slack was a tremendous success for the company, its shareholders, and our nation's capital markets. From our vantage point, we stand firmly behind the integrity and transparency of the listing and pricing process on this important transaction." Citadel Securities spokesman Zia Ahmed. In this same article, GTS Securities declined to comment. The Slack case centered on Section 11 of the Securities Act, which deals with the liability of issuers and certain others for material misstatements or omissions in registration statements. The Supreme Court ultimately ruled in favor of Slack because the court held that investors must prove that the shares they purchased were traceable to the allegedly misleading registration statement in order to bring a claim under Section 11 of the Securities Act. It would be interesting to know if Citadel felt a certain way about Rubenstein's statement contradicting their own back in 2019. Not related, but it's also interesting that FINRA believes their immunity protects them from misleading investors via fraudulent corporate actions. If Section 11 of the Securities Act were to apply in a situation like this, every investor would be able to trace their decision to either hold, buy, or sell to the misleading corporate action posted by FINRA. And in another scenario, one where perhaps the SEC accused the issuer of misleading investors into buying and/or holding a security. Similar to the ruling in the Slack case, how could a court determine which investors bought and/or held their securities due to the alleged misleading information? Overstock had been manipulated a number of years in the market. Though it took a significant amount of time and money, the courts ultimately ruled against the short sellers that claimed Overstock's business decisions were devised to cause them harm. One aspect of Overstock's business strategy was cryptocurrency. When Overstock issued their dividend, the original plan was for it to only be tradable via the T0 blockchain platform. Even though the dividend wasn't intended to trade on any other platform, the recipients of the dividend were investors that traded on exchanges, so they still had to get a T0 account in order to trade their dividend. I presume that in assigning a QSIP to the dividend, this was intended to make it easy for investors to transfer their dividend from the brokerages where they held Overstock to the T0 platform. At some point, against the wishes of Overstock, the Overstock dividend became tradable as OSTKO on the OTC. Ari Rubenstein's GTS Securities was amongst the market makers found trading the dividend, and they were contacted by Overstock's legal team on May 7, 2020. In a May 18, 2020 Bloomberg article, Ari Rubenstein was on record saying that the dividend violated the principles of free and fair markets and made it very challenging for his firm to ensure it was getting the best price for clients. "This is flatly against everything we believe in," Rubenstein said. "America's market system is not based on dictating the trading venue and charging exorbitant fees." In the same article, Georgetown University professor James Angel was quoted, "This raises fundamental questions about the rights of shareholders." The article also mentioned that Angel held some Overstock shares and followed the company closely. Shortly afterwards, GTS received clearance from FINRA to continue trading the dividend. Not mentioned in the article was that Ari Rubenstein was a member of FINRA's Market Surveillance Advisory Group. Also not mentioned was that James Angel's program at Georgetown University was closely associated with FINRA. The story we're told is that in 2021, broker-dealers relied on an exemption to Rule 15c211 that allowed them to publish a quote for unsolicited trades in the Series A preferred share of metamaterials. This of course meant that a Form 211 wasn't required, but there definitely should have been some documentation. The reason we know that GTS Securities was involved in the earliest trades of MMTLP is because of a response from TD Ameritrade to a client shortly after MMTLP became tradable. This response provided an unbiased account of what occurred behind the scenes. A portion of the October 14, 2021 message reads, "Currently, there is only one market destination accepting orders for MMTLP, which is GTS OTC. Unfortunately, our platform is not connected to this specific market destination for clients utilizing the Thinkorswim platform and advanced trading features, which is why the orders you placed we rejected." Interestingly, the TD Ameritrade message also identified Canaccord Genuity as working with GTS Securities in this portion of the message. There was one order that was filled on October 8, 2021, and I was able to confirm that our order room directly worked with a market destination, Canaccord, listed as C. Stewart in the details of that specific order, to confirm that they would be accepting orders for this security. However, during that trading day they stopped taking orders on it altogether. Unfortunately, we do not have information as to why they, or other marker destinations, have chosen not to accept orders for MMTLP at this time. The C. Stewart name that Canaccord was using was short for Colin Stewart Hawkpoint, a defunct broker that Canaccord Genuity acquired a decade earlier. Any idea why Canaccord tried to disguise their involvement? Doesn't this give the impression that they had something to hide? Well, on August 14, 2019, in the matter of Canaccord Genuity, the SEC instituted an order instituting administrative and cease and desist proceedings, pursuant to Sections 15, B, and 21C of the Securities Exchange Act of 1934. These proceedings concern Canaccord's failure to comply with its obligations under Rule 15c2, 11 of the Exchange Act to collect, review, and retain issuer information from at least October 2017 through September 2018, the relevant period. Canaccord willfully violated Section 15c2 of the Exchange Act and Rule 15c2, 11 thereunder by publishing quotations for dozens of over-the-counter OTC and non-exchange listed securities without a reasonable basis for believing that the issuer information was accurate in all material respects and was obtained from a reliable source. Canaccord has since revised and improved its policies and procedures with respect to Rule 15c2 to 11 inches. So Canaccord Genuity has a history of listing securities on the OTC without a reasonable basis for believing that the information was accurate or from a reliable source. And according to TD Ameritrade, they were involved along with GTS Securities in what appears to have been the earliest trades of MMTLP. But not only that, they were attempting to disguise their involvement, presumably due to their history of Rule 15c 211 violations. When you take all this into consideration, in addition to both GTS Securities and Canaccord Genuity being named in at least 2 spoofing cases together, their other disclosure histories, as well as the proximity of their offices both domestic and foreign, you get the impression that these 2 firms worked together, and that they were either involved in getting MMTLP tradable, or they know the parties responsible. It's actually baffling that both FINRA and the SEC know the reputations of these firms, but they've yet to investigate their involvement in TRCH, MMAT, and MMTLP. But there's more. On November 30th, 2022, at 8:55 in the morning, Ari Rubenstein made a post on the X platform in support of Virtu Financial suing the SEC over a lack of transparency. This post marked Rubenstein's disappearance from social media and the public eye. Also on November 30th, 2022, at 7:27 p.m., George Palikaris, then CEO of Meta Materials, made a post on X informing the public that he met with FINRA and provided guidance for the MMTLP corporate action. The guidance, according to the post, matched both what Meta Materials publicly shared in their November 23rd PR and the November 18th Next Bridge Hydrocarbons prospectus. Is it just a coincidence that Ari Rubenstein stopped posting on his X account that day? Is it a coincidence that Rubenstein stopped appearing on his GTS Securities and personal LinkedIn accounts, as well as no longer attending industry events? Let's take a brief moment to examine Rubenstein's actions and the outcomes in the Slack and OSTKO situations. Initially, Rubenstein made it sound like investors were wronged as a result of regulator shortcomings. Citadel claimed that everything went down without a hitch, and GTS declined to comment further. It's unknown how or if Ari Rubenstein was affected by the making that initial statement. When OSTKO was in the news, Rubenstein said that Overstock's actions were against everything he believed in. Overstock's lawyers were in touch with Rubenstein, and based on this post featuring former Overstock CEO Patrick Byrne, the outcome of the case wasn't in Rubenstein's favor. So given that things haven't appeared to work in Rubenstein's favor when he made public statements, it should come as no surprise that he didn't publicly comment about MMTLP. But just because Rubenstein disappeared, it doesn't necessarily mean that he was silent, in my opinion. Rubenstein was also a co-founder of the now dismantled Modern Markets Initiative, a high-frequency trading lobbyist organization. When asked near the time of inception why Rubenstein believed Modern Markets Initiative was necessary, there's a small portion of a much larger response that stands out. We will respond in real time to debunk myths and spurious media reports. If you recall, Georgetown University professor James Angel was quoted in the same article as Rubenstein complaining about Overstock's actions. James Angel claimed to be an Overstock shareholder that was also concerned about the company's actions, but the article never mentioned that Angel was employed by Rubenstein's Modern Markets Initiative, and Rubenstein has cited Angel's work in comment letters. So while was Overstock eventually the recipient of a favorable outcome, it's hard to ignore that FINRA gave Rubenstein permission to continue trading Overstock's dividend, even though they knew it went against the issuer's wishes. Now combine this with the fact that Rubenstein was on FINRA's Market Surveillance Advisory Group, that Angel's program at Georgetown University was closely associated with FINRA, and that Angel was employed by Rubenstein's Modern Markets Initiative. What you get is the impression that protecting Overstock and their investors and maintaining market integrity were never the priority. This was clearly a case of FINRA looking out for FINRA. Now, as we transition back to MMTLP shortly after FINRA's U3 halt, James Angel made his presence known on social media. Angel claimed to be a shareholder since TRCH, but unlike the vast majority of the early social media chatter, Angel pointed the finger at the company and came to the defense of FINRA. As the MMTLP community grew in focus and organization, they began to brief congressional staffers in Washington, D.C. It was there that they learned that Angel was also meeting with the same staffers, sharing a PowerPoint presentation with Georgetown University graphics and misleading information in an attempt to counter the community's efforts. While evidence of Rubenstein's potential involvement in MMTLP did circulate, he was never the main focus. It's easy to imagine that by attempting to shift the blame on the company and/or inexperienced investors, this would have likely prevented any potential light being shown on the relationship between Ari Rubenstein, Canaccord Genuity, and FINRA. Were these examples of Rubenstein responding in real time to debunk myths and spurious reports? You'd think that identifying what we've already covered would have been enough to spur an investigation, but there's more. Alexander Osipovich, a Wall Street Journal contributor, contacted members of the MMTLP community under the guise of writing a story that captured the truth. Instead, the story he produced poked fun of the MMTLP community and attempted to twist the narrative. After a little digging, you discover that Ari Rubenstein has hosted Osipovich's articles on his GTS Securities website, and Rubenstein has cited Osipovich's work in comment letters. While Rubenstein was missing in action, Osipovich also promoted Rubenstein's partnership with Jukebox, a trading platform that allows for investing in music royalties. Then there's Brandon Kokkoden of Forbes. Kokkoden has had numerous negative interactions with the MMTLP community on social media, and he has a history of denying the claims of investor communities that attempt to expose manipulation. Coach Coden's proudest achievement is no doubt a first-of-its-kind Forbes cartoon that pokes fun of NextBridge hydrocarbons and MMTLP investors. The MMTLP community discovered from this LinkedIn post that it took 6 months to produce the work. Wasn't this an odd amount of time and effort to devote to spreading falsehoods about a company that doesn't even trade? What was their true motivation? Then we discovered that J.J. Kinahan, a senior advisor for Ari Rubenstein's Clearlist, has also been a Forbes contributor since 2012. A little more digging and you discover that Kirsten Wegner, the then CEO of Rubenstein's Modern Markets Initiative, was a guest on Kinahan's Real Talk on the TD Ameritrade network. It was in that appearance where they discussed the impact of high-frequency trading on investors that Wegner described GTS Securities' role on FINRA's Market Surveillance Advisory Group, where they utilized their technology to identify manipulation such as spoofing on behalf of other high-frequency trading firms. Fox News correspondent Charles Gasparino has antagonized stock communities for quite some time. Eventually, he too joined in on the MMTLP community, spreading misinformation surrounding his understanding of PRs that he claims informed investors that 12/8/22 would be the last MMTLP trading day. There's a less than 10-minute video on YouTube titled MMTLP, FINRA's Deception, Gasparino's Folly, that I believe does a good job at helping the view to understand why Gasparino is incorrect. I'm confident he's viewed the video. He was quiet for a little while, but he soon returned to spouting the same narrative as before. Gasparino has a relationship with the Milken Institute, and it was at one Milken conferences where he was on a panel with then Modern Markets Initiative CEO Kirsten Wegner, and it was at another conference where he was apparently seated with Ari Rubenstein. Former acting chair of the SEC, Michael Piwawar, is currently Executive Vice President of Finance at the Milken Institute. He's been with them for about 6.5 years. Piwawar wears many hats, though. He's been a senior advisor for Ari Rubenstein's GTS Securities since 2019, and a distinguished policy fellow with Georgetown University's Center for Financial Markets and Policy since 2018. There's no evidence of Piwawar publicly commenting about MMTLP, but it's interesting that he's linked to Ari Rubenstein's GTS Securities Georgetown University that's linked to James Angel and FINRA, and to the Milken Institute where Charles Gasparino, Kirsten Wegner, and Ari Rubenstein have attended conferences. Piwawar has also been a guest on Kirsten Wegner's Brown Bag Lunch Show, which was a component of Modern Markets Initiative. On that same topic, when James Angel was a guest on the Brown Bag Lunch Show, he proudly appeared with background that appeared to display his affinity for GTS Securities.